6, United States versus Christopher Doyon. Counsel, if you would please state your appearances and if we could begin with the government and then move to defendant.
Good morning, Your Honor. Susan Knight for the United States.
Good morning.
Good morning, Your Honor. Jay Rorty with Christopher Doyon. He is present by video. He consents to a video appearance based on the necessity of the pandemic.
Thank you. And thank you for that waiver. Yes, it is necessary for us to continue to do some of these hearings by Zoom. And this one certainly qualifies. All right, Ms. Knight, this is the initial appearance before me in this case, although this case was filed many years ago. What can you tell me?
Your Honor, thank you for signing the notice of related cases. Yes. I've been in touch with Mr. Rorty regarding discovery and producing discovery to him. There are also, Mr. Doyon has also been charged in the Middle District of Florida. And so I put Mr. Rorty in touch with AUSA Roger Handberg about a possible Rule 20 to the Northern District of California. So we are providing discovery. Mr. Rorty is exploring a Rule 20 transfer here. So that's the current status of the case.
Okay, and this is I'm just trying to figure out exactly what this was. This is a single defendant case, is that correct?
I'm sorry, Your Honor, CR 11-00683. There was a co-defendant, Joshua Cavelli, but his case resolved many years ago.
Thank you.
So he's been charged in that. And then we have the 2012 case, which is the failure to appear.
Right. And that's, well, that'll just trail along and we'll see how we handle that later. Mm-hmm. Okay, Mr. Rorty, what can you tell me?
Your Honor, I agree with all of Ms. Knight's representations. The parties have met and conferred, not only myself with Ms. Knight, but myself also with the Assistant United States Attorney in the Middle District of Florida. As Ms. Knight indicated, I anticipate receiving some discovery from the Middle District of Florida that will allow the potential for a global resolution through Rule 20 before this court as to all matters. As the court may glean from the indictment, both the Middle District of Florida case and the 2011 case involve computer intrusion. So I anticipate that there's a significant amount of discovery related to not only a variety of reports, but some significant digital discovery that may require analysis. Accordingly, it is my suggestion that we set the matter for further status, perhaps in early October, by which time I believe that we can both achieve the transmission of complete discovery as to all matters and reach at least a preliminary decision as to whether the matters may be resolved by that time. My suggestion might be October 5th or 12th, if those dates are available in the court and counsel's calendar.
Okay, so Ms. Knight, what kind of time frame do you think there'll be in transferring the Florida case to my docket?
Well, Your Honor, I think Mr. Rorty needs to further discuss and review the evidence from that case. So, and then decide whether, his client needs to make a decision, Mr. Doyon needs to make a decision on that. So, I'm deferring to Mr. Rorty on that regarding the analysis of that discovery.
That's fair. Then, Mr. Rorty, do you anticipate that by October you will have made that decision?
I certainly hope so. I'm assuming that the Middle District of Florida will provide sufficient discovery for Mr. Doyon and I to consult and make a decision regarding Rule 20. But I think at this point, it's premature to assume that the case will be transferred, only that by early October, we will have a report to the court as to whether or not that process should occur.
Okay, and that's certainly fair enough. Is the Florida case from the same era as this one, or is it newer?
Yes, it is, Your Honor. It's. I believe it's a 2013,
I believe.
Yeah, it's a 2013 charge alleging a violation. Yep. So that's correct.
Okay, well then we'll wait and see. I think it makes sense to give you a little bit of a runway to get the discovery and to evaluate these issues. So Tiffany, is there an early October date that would be available?
Yes, Your Honor, October 12th.
Okay, and is there a request to exclude time until that date, Mr. Rorty, for effective preparation?
There is, Your Honor, based on the representations I've made this morning, I believe that the review of the discovery I've described here will encompass the time between today and October 12th, and would request an exclusion of time for effective preparation of counsel on that basis.
All right, then I will grant that request. I will exclude time until October 12, 2021. I will set this matter for status hearing on October 12 at 9 a.m. And Ms. Knight, if you'd prepare stip in order to that effect, that would be helpful.
Yes, Your Honor.
Okay, and then and I guess I need an exclusion of time on the now related case in 12 CR 426. Is that correct? We're going to continue that one as well.
Yes, Your Honor.
And my request for exclusion of time was designed to encompass both cases. I should indicate that I have not received such discovery as there is with respect to that case as well, and we'll need to review that discovery also.
Okay, so Ms. Knight, if you could assist in that, I'd appreciate it.
Yes, Your Honor.
I do see in my file here that there was a judgment on forfeiture on the bond that was issued in 2012. I assume that's related to the separate charge in the 426 case. Is that correct?
Yes, Your Honor.
Okay, that's fine. All right then. And I don't even have both files in front of me today, but I will grant the request for exclusion of time in the companion case as well. And Ms. Knight, your stip in order will incorporate both cases so that it's clear that there's been an exclusion on both cases.
Yes, Your Honor.
Okay, well, thank
And
you all.
Your Honor, may I make one more comment?
Yes.
The court makes a good point regarding the prior forfeiture. Perhaps the record should indicate that I have notified the surety against whom forfeiture was levied of Mr. Doyon's presence in the district, to the extent that that surety has rights and remedies with respect to a rescind, to move the court to rescind forfeiture and set aside any forfeiture in that matter. I have notified that surety. I do not represent them, but they are on notice and may take action as they deem appropriate.
Okay, well, we'll wait and see. I don't know what the time limits are on that, but certainly if they have rights, they're welcome to pursue them before me.
Thank you, Your Honor.
All right, good. Thank you. Then I will see everyone in October. Mr. Doyon, I will see you again in October. All right. Thank you all.
Thank you.
And that's the only thing we have on Zoom.
Correct, Your Honor.
All right. See you in the courtroom then.
Recordings